Good afternoon, ladies and gentlemen. I'm Bernard Sklar, and I'm pleased to be the Master of Ceremonies for today's People with Disabilities Foundation seminar entitled Accommodating Employees and Job Applicants with Psychiatric Disabilities in the Workplace. The People with Disabilities Foundation was created last year with a mission of total integration of people with physical, mental, or physical and mental impairments into the rest of society. This is the second of a series of public awareness seminars. The first seminar was presented in January of this year and was entitled Disabled Students in Elementary and Secondary Schools, Sensitivity Training and Coping Skills. Our next seminar will be Social Security Disability Hearings and Appeals and Work Incentive Programs in Disability. Our fourth in this series will be Housing for the Severely Disabled. As some of you may know, the Rehabilitation Act of 1973 was the first major congressional act that addressed the need for equality of individuals who were then called handicapped persons, so that these individuals could achieve equal opportunity in programs and institutions which receive federal financial assistance. Later, in 1990, President Bush expanded that area of law to cover not only governmental entities and others receiving federal monies, but the private sector as well. Although much progress has been made, especially with respect to people with physical disabilities, such as those in wheelchairs needing access by removal of architectural barriers, as of today, parity does not exist for people with mental impairments, period. Sorry about that. It's the purpose of today's seminar to focus on employment for people with mental disabilities in an attempt to further those individuals' rights to work, to build self-esteem, and to generally have the same employment opportunities, responsibilities, and benefits as those of all other people. People with Disabilities Foundation is pleased to have a panel of experts consisting of Dr. William Fry, Emeritus Associate Clinical Professor at Stanford University, Life Fellow of the American Psychiatric Association, Diplomat of the American Board of Psychiatry. Dr. Fry has 40 years of clinical experience and is an active member of the California State Medical Qualifying Board. He believes in equal opportunity for those mentally impaired and equal to those who are physically impaired or not impaired at all. Second, it's my pleasure to introduce Ms. Claudia Center, who's at the right, from the Employment Law Center here in San Francisco. She specializes in the employment rights of impaired individuals with mental disabilities. She founded the Libra Project, which lifts the invisible barriers through reasonable accommodations, which is an initiative to advance the very issues raised by this seminar. And third is Ms. Claudia Bird, a certified vocational rehabilitation counselor who has spent the last 12 years helping disabled people enter and re-enter the workplace, paying particular attention to those people with physical disability, with psychiatric disabilities and orthopedic disabilities. Last, I am pleased to introduce Mr. Stephen Bruce, who will moderate the seminar and begin the questioning of our panel of experts. Mr. Bruce is admitted to practice in California, Florida, and the District of Columbia, as well as before the United States Supreme Court, the Ninth Circuit Court of Appeals, the United States District Court for the Northern, Central, and Eastern Districts of California, and the Southern District of Florida. He has been employed by 2 federal civil rights offices, a senior attorney for the Social Security Administration Office of Hearing and Appeals, has been a public defender, and was a supervising attorney for a legal aid office. At present, he is a Social Security practitioner and the executive director of People with Disabilities Foundation. we welcome Stephen Bruce and the rest of our panelists. People with Disabilities Foundation, like other public charities, is dependent upon support and your tax-deductible contributions. These contributions can be made through the Foundation's headquarters here in San Francisco at 507 Polk Street. Other information regarding the People with Disabilities seminars and the Foundation can be found at the Foundation's website, www.pwdf.org. At this time, I am pleased to turn over the microphone to Stephen Bruce. Please feel free to raise your hands and ask questions when you have them. Mr. Bruce.
Thank you, Dr. Sklar. Claudia Center, years ago, when the Rehabilitation Act of 1973 was passed, the standard which has been applied and still is applied is that if an individual can do the basic job functions or essential duties of the job with reasonable accommodation, they must be afforded equal opportunity with all terms and conditions of employment. Over the years, these words have been interpreted differently or in a different way. I would ask you to tell us what is the current status of the law paying particular attention to individuals with mental impairments?
Well, I think you're exactly right about the intention of the anti-discrimination laws. The intention of both the federal and the state laws that prohibit disability discrimination is to allow people who are qualified to do the job to actually have access to that job, to have equal access, to have reasonable accommodations if they need them. What's happened over the years in the federal courts that have been interpreting our federal law, which is called the Americans with Disabilities Act, or the Rehabilitation Act is another act that provides for protection. What's happened is the federal courts have really focused on, not on whether the person can do the job, which is really the key civil rights issue. Is this person able to do the job? Is this person being given access to that job? Instead, the courts have really focused on whether or not the judge thinks the person has a quote-unquote disability. And the issue there, I think, is the sort of belief by a lot of people that, people, you don't really have a disability, you're faking, you're a malingerer. And those types of stereotypes actually go back to the Middle Ages. So that's a real, there's a long history of this sort of stereotype that people, especially with hidden disabilities, like a lot of psychiatric disabilities are really just faking it or just kind of looking for a free ride. So a lot of people who had disabilities such as bipolar disorder, depression, even schizophrenia were actually kicked out of court when they tried to bring their ADA claim because the federal judge said, well, we don't think you're disabled, and they used the federal law definition to make the definition very, very narrow and kick people out of court. What we have done in California is that we worked with a broad coalition of disability groups to enact an amendment to our state law that makes it clear that California rejects that federal line of cases that kicks people out for not being disabled. And in California, what we say is that it's a broad definition of disability. The focus should be on whether the person can do the job, that even if the person is currently stable because they found the right medications and treatments, that they are still protected by the law. So we're really hoping that this law became effective January of 2001. We're really hoping that this will be a new day for equal opportunity, at least in California. Unfortunately, we haven't fixed the rest of the states yet, but that's my answer to that question.
Claudia, the new law in California, what is the name of it? And could you articulate with a little bit more specificity how it deals with the problems that the federal case law seems not to address sufficiently?
Basically, under the federal law, there's a definition of disability under the ADA and the Rehabilitation Act that was you were disabled if you had a physical or mental impairment that substantially limited one or more major life activity. And what the courts didn't narrow this physical or mental impairment part. They gave a pretty broad definition to that piece. But what they did is they said, well, substantially limits has to be like really, really limited. So unless you were sort of in a coma, the courts would say, well, you're not substantially limited. You're limited, you know, maybe you're very limited, but you're not substantially limited. The third thing the courts did is they narrowed the list of major life activities. So for example, there was one person who filed a lawsuit in Maine who had major depression and was having difficulty interacting with people. He could go to work, although at one point he needed a leave of absence. But he had difficulty being around people, going out to public places. He was very severely clinically depressed. And the court said that, he said, well, I'm limited in the major life activity of interacting with others. And the court said, well, we don't believe that that's a major life activity, interacting with others. So they kicked that person out of court. And then finally, the fourth thing that the federal courts have done is, and this was sort of culminated in the 1999 Supreme Court rulings that you may have read about in the newspaper. They're kind of called the myopic pilot cases. What they said was, if you're currently doing well because you're taking your medications and you're going to your therapist and you're going to the gym and you're eating right, if you're currently doing well, even though you have bipolar disorder or depression or obsessive compulsive disorder, then you're no longer covered because you're doing so well, you're no longer substantially limited. So people are saying, well, gosh, I mean, I thought I should be rewarded for taking responsibility for my health care and doing really well and being a good employee, and now you're telling me I can get discriminated against simply because I'm doing well and I'm no longer protected. So what we did in California is we basically modified all of these prongs to make it clear that we were rejecting that federal law. And so for limits, we made it clear that it was only a limit. It doesn't have to be a substantial limitation, because the courts had really gone hog wild with that word substantial. And then with major life activity, we said that major life activity must be broadly construed to include physical activities, employment activities, social activities, mental activities. And then finally, we said that even if you're doing well right now with what's called mitigating measures, like medication, that you're still protected under California law. So basically, we tried to address every problem that the federal courts had created. And that's what the law was. The law did some other things too, but that's one of the key things that the law did.
Briefly, what is the exact name of the new law? When was it implemented?
The law went into effect January 1 of 2001, and it's called the Prudence K. Poppink Act. Prudence was a lawyer in our community who dedicated more than 20 years to disability rights enforcement, and she herself had a disability. She had breast cancer, which then went into remission. And under what the Supreme Court said, once she was in remission, she would no longer be protected because she would, be doing okay. And so she had a very personal knowledge of why that type of analysis was unfair. And she worked with us very hard on this legislation. During the time that we were working on the legislation, her cancer came back and she passed away in late 2000. So the bill is named after her.
Thank you. And in the new California statute, does it delineate limitations in terms of defenses that an employer might use if accused of violating the act, such as undue hardship, or, is that expressly stated within the statute?
Yes, there are a number of defenses the employer can look to. First of all, the employee has to be qualified to perform the essential functions of the job with the accommodation. So the employer could say, well, even though you have a disability, you're not able to do the essential functions of the job. Let's say somebody has a disability where they have difficulty talking on the phone to the public. If that person is in charge of answering phones, if that's an essential function of their job, then even though it's true that they have a disability, even with an accommodation, it would be unclear that that person could actually do the essential functions of the job. Now, that doesn't mean that the employer doesn't have some other duties. That employer would have to look and see if there's a vacant job that that person could perform. But basically, if the employer can prove that the person can't do the job and that there's no vacant job that person can do, that's a defense. Another thing the employer can say is, well, yes, you asked for an accommodation, but this accommodation was too disruptive, too burdensome, too expensive. So they have an undue hardship defense, undue burden defense. Another thing that the employer could say is, your disability falls into a list of disabilities that are excluded expressly, such as the current use of illegal drugs. That is expressly excluded. If you're in rehab and you're not currently using, then you would be protected. But if you're currently using illegal drugs, you would not be protected. So those are the types of defenses that the employer can use, even if the employee is successful in proving that they have a disability.
Claudia, how would one get qualified, and who has the credentials to state that the individual is qualified?
Qualified or disabled, or either?
No, qualified for the new legislation effective January. In other words, qualified disabled individual. Is this someone from Voc Rehab who can state that they're qualified to fall within the purview of the statute and have its protections?
Well, it kind of works on a case-by-case basis. If somebody is in the workplace and requests an accommodation, tells their employer, for example, I need to leave a little early on Wednesdays for my therapy, and that's the only time I can schedule my therapy, and I need it for my disability. The employer could say, okay, you have that accommodation. If that's true, then the medical certification doesn't really come up because the employer doesn't ask for it. The employer does have a right to ask for it, though. The employer can say, that's fine, you can leave a little early on Wednesday, but I need some medical documentation, confirming that you have this disability and you need this accommodation of leaving early on Wednesday. So then what the person would do is go to a qualified healthcare professional. It doesn't need to be a psychiatrist or a doctor, although some employers don't like having notes from other professionals, so it may be just faster if you have access to a psychiatrist or a doctor to use that person. But basically it's just a doctor's note saying, so-and-so has this condition. Because of this condition, they're limited in a major life activity. You have to follow the definition and say how they're limited in the major life activity. And because of this condition, this person needs blank, and kind of fill in the name of a description of what it is they need on the job. So there's no real rules about who can fill out this medical certification or a doctor's note. In fact, the EEOC, which is the federal agency which enforces the ADA, the Americans with Disabilities Act, they've kind of given a long list of providers that they think are acceptable, which goes through, psychologists, psychiatrists, doctors, social worker. So, anyone with those types of credentials could go ahead and write the note.
Claudia, I was wondering, and maybe it's best if I ask this by way of example. Suppose someone has a mental impairment which is noticeable to co-employees in the workplace, and the co-employees are making fun of her to the point where it interferes with the individual who's mentally impaired with her ability to perform her job. And I guess further assume that the employer knows about it because it's been documented by maybe a first-line manager or something. What rights and remedies, if any, does this individual have in this situation?
That is a great question, and I've actually seen examples similar to what you're describing, and I've also read some cases where somebody, this particularly happens where someone takes a leave of absence because they've gone into a psychiatric hospital, and their coworkers find out where they've been. So the person comes back to work, and they're sort of, oh, so-and-so's crazy, or oh, look out, loony guy is coming. And so there's all these sort of like the equivalent of a racial slur, only for a mental disability. Crazy, psycho, all of those types of stereotypes can come up, and they're very obviously ugly. And basically, in that situation, the individual employee would have the same rights as anyone who was subjected to unlawful harassment. You've heard the word harassment or sexual harassment. If you're on the job and you're getting harassed by your co-employees, your coworkers, and if that harassment is on a basis like sex or race or disability, then that's unlawful harassment. And the employer has a duty, an affirmative duty, to investigate the harassment and to take affirmative steps to stop it, such as sitting the coworkers down and saying, you stop it, or you'll be disciplined, or even issuing discipline if there's already been a lot of harassment.
Thank you. Let me add one more part to this question. What really, and if you don't know, this may be a difficult question, but the practical scenario where information has been disseminated throughout the office and the employer has a duty to not have the work environment hostile, so to speak. As a practical matter, do you have any knowledge of situations where it has been successful or it hasn't, and if so, why? It would appear to me that sitting down and getting people's attention and trying to sensitize them would be a logical approach, but in the real world, and maybe we can go into this later more with Dr. Fry, but from cases you're aware of, from a legal point of view, is this an effective and adequate remedy for the employer, the one you described?
Well, I don't know that it's adequate, but it's certainly essential and necessary that we have those steps taken by the employer. It's very analogous, I think, to situations where there is race harassment or sexual harassment. It may be that the particular culture in that workplace is very hostile, and that sitting down with people and trying to sensitize them is ineffective or not effective enough. And then you have to escalate the discipline and escalate the steps that you take to make sure that the employees do not continue the harassment. What often happens, of course, is that the supervisors either don't care about the harassment or themselves are participating in the harassment. And so in that situation, of course, it is difficult. You have to then try to give notice to someone above your supervisor. And sometimes those situations end up turning into litigation. I had a case where a man was clinically depressed and was asking for a leave of absence because he was very sick with depression, and his supervisor kept yelling at him and saying, oh, suck it up and be a man and get to work, and everyone's got problems, and you gotta suck it up and keep going, and what's wrong with you? And this kind of yelling went on, and the other coworkers could hear it. And so in that situation, it's very difficult to get a remedy internally, and he ended up turning to a litigation-type strategy.
With respect to someone who has a chemical dependence or addiction, and what obligations, if any, does the employer have not to disseminate the information to the employees, the staff? I mean, is there any guidance in the law on this point? For example, if someone is in rehab, is not actively using an addictive substance, whether it's alcohol or some other chemical, is the employer permitted to inform the other employees that so-and-so, is a junkie or is in the, just getting out of the detox unit? Are there any parameters in the law on that subject?
Yes, there are rules in both the federal law and the state law that basically require employers to maintain all medical information obtained from their employees in confidence. That means that if there are documents, for example, from a psychiatrist or psychiatric hospital stating, so-and-so is inpatient for 4 weeks, needs a leave of absence, those types of documents have to be maintained in confidence. They have to be maintained in files that are completely separate from personnel files. Most employers don't know this and are still violating this rule, but the documents have to be kept separate from regular personnel documents. Also, the employer is not allowed to tell people, information about the individual's disability or diagnosis or medical condition. Again, this is often violated. So yeah, I mean, there is in the law a requirement of confidentiality. In the real world, a lot of times people find out. So that's kind of the real world. Should I take? Okay, yeah.
The employer seems to be in a catch-22. He's legally not allowed to tell anybody that the employee has a psychological disability, but at the same time he has to defend the employee against the psychological slurs of the other employees. Seems like a no-win situation for the employer.
Well, I'm not sure.
I'm not allowed to
understand.
tell you that Mr. Smith just spent 4 weeks in the hospital for depression, but I do have to tell you to stop criticizing him for being depressed and not working as well as he should because of his psychiatric disability.
Well, I think employers are pretty good at instructing their employees without giving a lot of information. I think that that's something that managers are capable of doing, and once a manager is put on notice that this situation is happening, they don't need to tell the employees anything more about the situation. They just need to tell the employees, I've heard that you are using these types of slurs against this your coworker, and I want you to stop. There's no need for the coworker to know anything further. This coworker has already demonstrated that they are incapable of, sort of responsibly handling this type of information. So I think there are situations where the employer is in a tough situation. I will admit that, even though, I tend not to, my sympathies are on the other side usually, but I don't think that this is an example of where it's that difficult.
Yes, the gentleman in the blue shirt.
If an employee is receiving a medication for some psychiatric disorder and that medication is being adjusted, this leads the employee to have some difficulties missing work, perhaps various kinds of symptoms that appear in the workplace. Is that covered as a disability?
That is a very common situation, and I would say yes, it is most likely covered by the state law. Very common for someone to be doing very well on a particular medication, be in a very stable situation, maybe have worked for their employer for several years, and the employer may not even know that this person has a psychiatric condition. For whatever reason, times change, medication changes, people's bodies change, they need to switch medications. And there can be an adjustment for certain conditions while the new medication is getting into the system. And so that person may have symptoms at work. And at that point, it kind of depends on what the symptom is and what the employer knows. For example, if somebody kind of acts like a jerk and starts yelling at people, but no one knows that that person has a psychiatric condition or that it's related to a medication, that person can be terminated or disciplined because you can't sort of expect not to be treated just like anyone else who's yelling at somebody for no reason. If the person says to their supervisor, I'm having difficulty with my medication, it's a new medication, I have a psychiatric condition or I have a medical condition, and therefore I'm having difficulty in the mornings, and so I may be late for the next 2 or 3 weeks, and as an accommodation I want to work longer at the end of the day. That would be a situation where the person would have a lot more protection because they've told their employer, what's going on. They've tried to explain what accommodation they might need to deal with the side effects and symptoms related to the new medication. If the situation is such that the person is not able to do their job, is not able to work at all with coworkers, is not able to work at all with their supervisors, is acting out such that it's disruptive to the workplace, at that point the accommodation is really going to be a leave of absence until the medications stable out, because the employer does not have to have someone in the workplace that is very disruptive or very hostile And in fact, no one, I've never even had a case where someone was trying to say that their employer had to tolerate that kind of behavior. That's kind of something that, like the Wall Street Journal always does these sort of anti-ADA stories where they talk about, that the employer has to keep this screaming, violent lunatic at work, and that's actually not what the law says. And so if someone was really sort of acting out and super symptomatic, they'd really just have to take a leave of absence because they wouldn't be qualified at that time to be in the workplace.
Yes, the lady in the first row.
Okay. I think that some employers use the excuse that persons with psychiatric disabilities could be a danger in the workplace and use that as an excuse not to even hire a person with a psychiatric disability. Can you comment on that?
That is, very, very, very common stereotype. And, turn on the television for an evening and you'll see several examples of violent people with psychiatric conditions. So that's very, very prevalent. And one of the things that happens, a lot of times the employer doesn't know that the person has a psychiatric condition when they're hired. If they do know, I think that stereotype does come into play, and there may be a desire by that employer to avoid hiring someone that they perceive as dangerous. Another thing that happens is if the person discloses a psychiatric condition while they're on the job after they've been there for a while, suddenly that person is really sort of surveilled and scrutinized more closely, and anything that they do that's even the slightest bit odd, even though we're all very odd in our own ways, whether or not we have disabilities, anything that that person does is sort of seen as threatening or dangerous. For example, I had a client who had bipolar disorder, a very talented chemist, and he told his supervisor, I'm having trouble with this bipolar disorder, I'm having an episode where I'm manic, and they said, okay, take a leave of absence until you're stable. So he goes to pack up his car, and he's manic, so he's packing boxes and moving boxes into his car, and then he's taking stuff out of his car and moving it back into the office, and he's moving stuff around, and he's just really hyper and manic. So they see him moving these boxes around, and they suddenly decide that he must be doing something against the company, that this is all sort of a plot, and that maybe one of these boxes has a bomb, and that, who moved these boxes, and so they actually evacuated the entire building because they decided that there must be a bomb in one of these boxes. And meanwhile, he's just packing and being manic. And so of course there's no bomb, and then they fire him because they say, well, you disrupted the workplace because we had to evacuate the building. So, and we ended up settling that case because I think the lawyer on the other side realized, how that stereotype really took a situation and got it way out of control. But that can be a really difficult stereotype to overcome. I think that the more that we can have these public kind of seminars and educate the community about the, real statistics about violence and psychiatric diagnoses, which is there's, no link whatsoever in the absence of substance abuse. And fortunately, the MacArthur Foundation has spent a lot of time trying to get that information out to the public, and we just need to keep working on it.
Claudia, one last question before we move on to Dr. Fry, and I do hope you will be available for more questions later in the seminar. I wonder, in this situation, if an employee is showing signs of behavior that is inconsistent with his or her prior behavior on the job, whether it's paranoia or whether it's unresponsiveness, lack of ability to concentrate and remember, at what point does the employee have a duty to notify the employer of the condition? And in the alternative, at what point is the employer charged with knowledge of this condition?
That's a really good question, and that actually is a situation where I think it can be difficult for the employer. I think I mentioned before there are some situations where the employer has to kind of act very gingerly and be very careful, and it is difficult for the employer. In the situation where the employee is having difficulty on the job and has not disclosed a disability or requested accommodation, basically, they don't have to disclose anything at any time, but their job is going to be at risk if they don't sort of explain what's going on, because if they're as symptomatic as you described, they're probably not performing their job as well as they had been before. They're probably missing deadlines or not producing quality work or whatever it is. So that person is really at risk of any sort of discipline or termination that any other person would be at risk for, given a slump in performance. If there's some more information that is provided by the symptoms, by the actions, if the person, for example, has told the employer that they're having a medical problem, or has previously told the employer of something about a psychiatric condition. If there's something very obvious that the person has a psychiatric condition, when that can be very subjective, and some employers may or may not know, there may come a point where the employer might be charged with knowing that this person has a disability if enough information is disseminated. And what I would suggest to employers is that they kind of sit down and ask open-ended questions to the employee, but not necessarily medical questions, but questions such as, I've noticed you've been having some trouble at work. Is there anything we can do to help you perform up to your usual standard? Are you aware of our policies that are in our handbook? Are you aware of our policy on medical leave? Are you aware of our policy on reasonable accommodation? Please know that the channels are open, and just try to give the employee an opportunity to try and articulate what it is that they may need. That's kind of the best advice I could give for the employer side. If the employer really doesn't know, then the employer has no obligation under the ADA to engage in a discussion about accommodations.
Thank you. The gentleman in the second row, blue.
My name is Ed Regan. I live out around 19th and Tarryville. I'm a Social Security recipient. I just happened to come in here, and I would like to know, do you think that a training program, a paid training program for various occupations of low level would cure some of this, what you call mental disability?
Well, I think that one of the reasons that the employment provisions of the ADA and of our state law are so important is that for many people with psychiatric conditions, and I would include myself in this category, working is really important to our stability and to our mental health. And it's when people are not working, that, for a lot of people, that their conditions become very symptomatic, that they become very ill, that they become very depressed. And that's certainly been my experience. So I think that working is actually part of recovery and part of mental wellness for a lot of people with psychiatric conditions. So the more we can encourage work, I think it's true, the more stable people are going to be overall, and the more capable people are going to be. So it's really a win-win in that way, so I would agree with you.
Don't you think that you have any ideas on who maybe should be running these programs, such as the state or the counties?
Well, certainly people have had a lot of concerns about work training programs over the years. And I'm not a benefits lawyer, but a lot of these concerns were debated and discussed during the, let's see if I can remember all the words, the Ticket to Work, Work Incentives Improvement Act of 99?
1999.
Okay. TWIA. And so there is, the idea is that there will be more flexibility in terms of who runs these training programs. But I'm not really an expert in that area. I do know that there is a desire by many to kind of have a range of agencies provide these services, including some that are more of a nonprofit or community-based agencies as opposed to state agencies.
Thank you very much.